Forward. At last, she earned her bachelor's in 2008 from Marmara University, and she is also a trademark attorney since 2013. And the floor is yours.
Hi everyone. Can you hear me? Just give me a second. Yes, please. In fact, this is going to be a kind of free speech because, as you may point out from my resume, I'm not engaged in IP community. In fact, of course, I'm handling some IP-related matters, but it's just mostly since I'm engaged in fashion industries, mostly about industrial designs and trademarks. And I cannot help myself to state that I just once more realized that this is my opinion, but I'm a Turkish practitioner, so I can state that we're far short from the UK, US, and EU member countries in terms of IP protection, from my aspect. As some of you may have the attention to the background of the company that I've been working for, we sold a system under a company to Walmart 5 years ago, and it definitely come up with the IP matters, copyright licensing, trademark assignments, and so on. Since then, we put far more attention to the IP protection. However, I cannot tell you that as a developing country, still developing country, that we have the essential attention to the IP protection. It also captured my attention that the majority of the speeches, apart from Nick and the Italian colleague Luca, who spoke about Armani, were related to patents. As said, I mostly deal with industrial design and trademark-related matters. Nevertheless, I used to advise Startup Factory, which was a strategic partnership of a Turkish university and a Turkish leading telecommunication company, Turkcell, maybe some of you know, which is founded to accelerate commercialization of ideas and technologies and to promote entrepreneurship. So during that period, I have come across with young people having an idea in their minds who needs to be led by the right mentors and capital for creating a product from that idea. In this short presentation, I cannot see it still. I'll try to summarize the facts and the considerations that I will pursue with as if I was an entrepreneur.
Oh yeah. Thank you for reminding me.
You're welcome.
Thank you, Seda.
You're welcome. No, it's
We were
my
doing
bad.
some editing
I had to
earlier.
switch from
Yeah.
duplicating screens, and that's why.
It's a really simple, short presentation. As you already know, one of the most critical challenges that startups may face is to ensure protection of their intellectual property rights with a tight budget. Therefore, they shall prioritize their intellectual property spend to help achieve desired overall business strategy. As the costs and professional fees should also be taken into consideration while they do prepare their business plan. So this would also attract investors and also put a barrier against potential competitors. So due to the tight budgets, a startup shall have a better understanding on the IP protection compared to the well-established companies, maybe, or the value that IP can have to their businesses. I also, every time, whenever I met an entrepreneur, I just remind them that you should be aware of the fact that your IP rights should be subscribed as a capital in kind and represented by a share certificate. So they can also subscribe it as a capital, at least in Turkey. So the other management tip I would advise to a startup company to set up a system to ensure that the creator of the IP rights, engineers, and the management teams are in contact, regularly. This shall also be ensured through the provisions of the employment contracts, which shall put liability on the company, I mean the employer, to provide necessary equipment to the employee, and also employee to inform the employer to inform its employer on each creation. And also the assignment of the rights of the IP to the employer, I mean the startup. And also from the aspect of the investors, whenever they provide the idea, or at least before intellectual property becomes, they should have signed NDAs, I mean non-confidentiality agreements with the potential investors. So the, okay. This section is called IP protection for startups. Will it become costly? So I want to lay out the fees for IP protection in Turkey. Most of the startups, even the individuals, file trademark application in Turkey in order to get the domain name, I mean country code of the domain name, .com.tr. So we have no problems with the local trademark application, and it's quite reasonable. Fees are quite reasonable. And also for patents and industrial designs, it's just quite reasonable in comparison to EU countries. But when it comes to overseas trademark applications or overseas patent applications, it's higher, despite Turkey is a contracting party to the Madrid Agreement. So therefore, the Ministry of Economy has introduced some incentives to support Turkish companies' overseas operations and export activities, where you can gain 50% of your costs and fees paid back within 6 months. And also, this will not apply to a startup, but if you have an investor and if you can set up a true system, you can benefit from this accreditation system because there is no upper limit. This is limited with 100,000 US dollars, I guess. But this incentive doesn't have any upper limit. So I'm going back. Our IP rights used to be governed by decree laws until this year. But lately, we had the first industrial property code. And the general preamble states that the new code aims to comply with the recent developments in EU IP legislation, which is a chance by our Turkish colleagues. And also it has more clear format than, since they were governed by the decree laws, it was too complicated to understand, and you should have followed each separate decree laws, but now it's now under the same umbrella. And it's just we hope that it's gonna be have some shorter periods in comparison to the decree laws to register your trademarks and patents and industrial designs. And also there are some effective solutions for disputes and registrations, which will judges will also will benefit from those. So, as most of the colleagues already state in their presentations, I would suggest to a startup to formulate a clear and effective IP strategy from scratch, since the litigation costs and attorney costs will cost much more higher than the cost of official fees or attorney fees to be paid for, at least for application. And there are some, having checked the alternative service offerings, I have come across with Patent Cam, for example. I'm not sure if it's free, but it's cost effective. I use TMView and also WIPO's trademark search, and I also recommend my other colleagues in other departments to use this service offerings. So if a true and appropriate IP strategy is not set up, then a startup may incur unexpected litigation costs which will have an adverse effect on the ongoing business. And also a court case may disrupt the activities and directly affects its profitability. So this should be kept in mind by the startups. To sum up, if I was an entrepreneur, I will have a clear IP strategy from scratch. And I will apply for and use the trademark genuinely within the classes that my company operates, because even in Turkey has introduced a non-use defense lately. I will conduct periodic IP research, whether through IP lawyers or maybe, if possible, through the own personnel of the startup. I will execute NDAs with the potential investors. Watch for changes in how the law is interpreted, because it can be changed through the precedents of the Supreme Court. And as said already, I will put some non-competition clauses in the employment contract, and also monetary penalties for breach of IP rights in the employment contracts, so that at least we can put a barrier on the unfair competition. That's all. Thank you for listening.